And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I want to remind everybody, hit that like, share, and subscribe button for me. There's a PayPal link down below for anybody who wants to share some love. Every little bit is appreciated. And the StreamYard is pinned down there for anybody who wants to come join the panel. We're going to get right into it tonight. I thought I had some guests lined up that were going to show up, but we don't have anybody yet. So we're going to get right into it. Back to last Sunday night, indemnification, and the things we went over. And of course, we have Russ here with us tonight. How you doing tonight, Russ?
Good. Greetings. Hello, everyone. Hope everybody's having a good day.
Awesome. We're going to take off where we left off last week. We went over the securities exchange registration for a James A. William Trust for private placement in equity as a matter of indemnification and equity. And so tonight we're going to go over that definition, indemnity, and what it means. And here it says on Entom Online, it says security or exemption against damage, loss, etc. Security for damage, unhurt, undamaged, as in is not, or opposite of, or without. So indem is not harmed, not damaged. See in, and then damnum, damage. So it's not damaged. See dam, meaning legal exemption. Legal exemption. And why are we talking about a legal exemption? Because they made a legal exception and said that you're qualified because there are exceptions. Well, those exceptions, what they do is they actually harm us. Without being properly educated of legal ease, we enter into all these implied. Excuse me. We end up signing into all these contracts that have certain implications that we're not fully aware of because we don't read them. We don't read the small print, things like that. And I urge people to really start doing that. When you start reading these contracts, you find things that might be to your advantage, one of which I'll read real quick. Excuse me here. And this is from the emergency room at the local hospital from when I found out I had cancer. And you can see it says sales agreement from the local emergency, Allen ER. Date of service, Allen ER. Unity Point Health. Okay. On this document, on the back, as it says, it's a sales agreement. And on the back, it's got some contract clauses. Various different, and down here in the sales agreement, I'm going to read this one right here. It says, the customer agrees to pay the stated price for the equipment. Remember, this is a service agreement. For the equipment, it being understood that credit will be given to the customer's account for payments received from any medical insurance program or from any third party. So myself being a third party to their contract that's already in play, as the customer, I agree to make that third party payment so long as it's understood that credit is given to my account. Again, remember the basis is the customer agrees to pay the stated price for the equipment, it being understood that credit will be given to the customer's account. So if the customer's paying and the credit is supposed to be given to the customer's account, that's circulation. That's currency. Greetings, Steve. How you doing tonight?
I'm all right, brother. Just running around.
Yep.
Trying to catch myself.
I hear you. I hope things are going better today.
Good to see you, Steve.
Likewise.
So we're going over indemnification, indemnity and stuff tonight. We're going to go over it in detail in regards to how we spoke about that securities exchange registration for private equity last week. So we want to get into the detail of what exactly is indemnity. So that's what we're going over. And as it says here, we go on, it says damn as a verb is a legal term to condemn. Now, before we go any further, I want to pull up King James Version, Isaiah 54, verse 17, to remind everybody no weapon that is formed against thee shall prosper, and every tongue that shall rise against thee in judgment thou shalt condemn. Because we're not supposed to be judging each other. We're not supposed to be condemning each other. It's the language that we use. So, again, this is why I say I don't hate anybody. I hate the things that we say and do to each other. And it says, thou shalt, that and every tongue that shall rise against thee in judgment, thou shalt condemn with damage. That's what you're doing. You're supposed to show that they're no good. Those words will harm you. And so we're supposed to rise up against that. This is the heritage of the servants of the Lord, and their righteousness is of me, saith the Lord. And this is the only way we can condemn those false words is with the right words. We have to know the right words, and we have to know what those languages are. That's why I love Steve and his diligence in looking in the various different jurisdictions. Many people don't understand there's that many jurisdictions, particularly people like Paul, who says there's 2 jurisdictions. While I agree there are 2 jurisdictions in that sense, we have to realize there's over 26 different jurisdictions, folks. They all use different grammar. So let's get back to it. On the indemnity, it says declare guilty, convict, doom to punishment in a future state, damn, condemn, evict, blame, injure, to a judge, guilty. And that's what they do in those courts. They're damning you. Again, just like they condemn the land. Who has the right to condemn the land if it's not theirs? Who has the right to condemn their brother if they're supposed to love their brother as themselves? See, all this stuff is backwards. And again, I remind you, those are just Article 1 corporate courts. Indemnify means compensate for loss or expense. So this is why if we put up an indemnification under that full faith and credit seal, that's where the payment comes from. Even if you do something wrong, it comes from that. And this, in this sense, is an equal consideration for their surety and indemnification, because you're not involved in the contract. But if their contract harms a third party outside of the contract, their contract doesn't involve that third party, and nor does their surety. Their indemnification goes for the parties in the contract. But the surety is availed for those that are third parties, but there are certain evidently alignments that have to be made. Indemnified, indemnifying. Indemnify formerly meant to save a person from damage or loss. But now, much more often, it means to make good after loss or damage of the property. And it has to do with insurance, restitution, redress. The doubling up, like I said before. Smart money. Money bet by those in the know. It's like I said, if you're going to play with the big dogs and you're playing in the wrong house, you're going to be controlled by their bet. But if you know who you are and they offer up 73 million, then you double it up like Revelations 18:6 says. You play smart money because you know whose money you're playing with. You're playing with the money of truth. And they're going to lose and they'll fold every time.
I think one thing to point out, all those words are the core of commerce.
Yep.
The remedy, restitution, indemnification. Some, like indemnification, kind of crosses through all of the jurisdictions, but restitution, those words are kind of in just those core places. So it's you got to be astute on where you're using that word. Right.
Yeah, you use exemption in one community, protection in another, restitution in another, insurance in another. See, insurance is an insurance, not a restitution, but both do the same thing. That's what we're talking about. There are different jurisdictions that use different languages.
Yes.
Exemption, compensation, relief, dresser. Who's the dresser? Remember, we saw the redress. Dresser. It's just a removal of the letters and switching around, but the dresser itself is a person who prepares or furnishes something. You know, like they furnish the nationality. And that's what needs to be redressed. Pure and simple. The next one. Indemnification clauses in contracts, and this is where we get into the details that Steve was talking about. They mean different, those different words, even though they all have a similar effect in the end as to a meaning of some sort. They're used differently throughout the different jurisdictions because of the different jurisdictions that have different contracts. But each of the contracts should have both an arbitration clause and an indemnification clause. All contracts should have those two main clauses. Indemnification clauses appear in nearly all commercial agreements. They are an essential risk allocation tool between the parties, and as such, they are one of the most commonly and heavily negotiated provisions in a contract. Really?
I'll agree with that one.
What is indemnification? You don't ever hear it at the employment. You don't ever hear it about insurance when you go get auto insurance or anything like that. And that's the problem. Certain people that are involved closely to the contracting, like yourself, would know that. But the general population doesn't. And they've never been taught it. Indemnification, also referred to as indemnity, is an undertaking by one party, the indemnifying party, to compensate the other party, the indemnified party, for certain costs and expenses, typically stemming from third-party claims. So the principal has a surety bond and an indemnification with that, and that covers him and his subordinates. So we, as a third party, make a contract with that principal, a simple contract, an indemnification contract, not for anything else, but for a private placement of indemnification against him, so long as any one of his subordinates that doesn't do things right, I get to make a claim against his bond, and it will automatically be paid out. He won't be held liable, and he can replace those people if he chooses to. Because if they come again and they violate me again, we're just going to keep upping the price. You want to keep those ignorant fucks on the payroll, then we'll make it really worth my time. I'm not going to play games anymore. Had a DHS worker at the fucking door today for crying out loud. It's fucking sickening.
What the hell was that for?
Because the neighbors want to complain about my yelling and think that my wife is in some kind of danger. So when she come to the door, hey, you got that third-party witness? Oh, no, we can't disclose those. Well, then you'll have to see me in court without a witness. Because I guarantee you, I'll put my motherfucking balls on the stand and testify. And my wifey here, she'll be right with me. People are stupid. So we continue on. It says indemnification can also cover direct claims, and that's what we're talking about, the direct claim, which are claims or cause of action that one contracting party has against the other. That's what theirs does. See, they're in contract. The mayor's in contract with the chief of police, and then he hires all these other subcontractors. Those are contracting parties. Okay, they're involved in an actual service or product contract. I'm not. This is merely an indemnification for those contracts so that when they breach them, I can be compensated under full faith and credit. Why are indemnification provisions important? Indemnification clauses allow a contracting party to customize the amount of risk it is willing to undertake in each transaction and with every counterparty. Like I said, if they've got a blanket surety bond for $73 million, then I'm going to double it. I'm willing to double it. You want to double it and get stupid and say, well, if you're going to double it, I'm going to double it. I'll just double it again. It's full faith and credit, which is an endless source. Protect itself from damages and lawsuits that are more efficiently borne by the counterparty. That are more efficiently borne by the counterparty. Why do you suppose that is? Because if a plaintiff brings a case and they're the debtor, the counterparty, being the defendant, is the creditor. For example, In a sale of goods agreement, the risk that a product injures a third party is more efficiently borne by the seller than by the buyer. The seller has more control over the goods than the buyer, whose principal obligation is to make a payment. The seller is therefore in better position to mitigate losses and liabilities related to the goods than the buyer, because they're the ones that have a mitigating contract still in play, that if they continue selling products that harm the customers, then they're the one that's going to have a claim against them. So again, it's the seller that's carrying that obligation still, because they're in contract. Same with these city officials. Drafting and negotiating an efficient indemnification provision benefits both the indemnified and the indemnifying party. An indemnification clause may allow the indemnified party to recover certain types of losses, such as attorney's fees, which are not typically recoverable under a common law cause of action. The indemnifying party to reduce its liability by incorporating. The indemnifying party to reduce its liability by incorporating. I thought it was already incorporated. It was a business, right? Nope. It's never been done. And it provides a liability cap, materiality qualifiers, and a liability basket. What are the components of a typical indemnification clause? A typical indemnification clause consists of two separate and distinct obligations: an obligation to indemnify and an obligation to defend. This is where that term diplomatic comes in, and the term grant. You have to have the ability to, under a grant, assure that the information is true, and under diplomacy, be able to communicate that appropriately without babbling. And those are your two obligations. The obligation to indemnify requires the indemnifying party to reimburse the indemnified party for its paid costs and expenses, referred to as losses. That's if I am actually the one that's at fault and I caused that expense, then I have to pay them through that indemnity. But again, it's coming from the full faith and credit of the seal, which establishes the connection with the estate that was created when we were born. Advance payment to the indemnified party for its unpaid costs and expenses. Advance payment to the indemnified party for its unpaid costs and expenses. That's the prepaid expense that I was talking about the other night. We've done that video before. Insurance and taxes are prepaid expenses. And as you saw in the video last night, there's a tax protection agreement. And all you have to do is get that SEC to certify your indemnification and match it up with the Postal Service indemnification under their tax protection agreement. That's my perception. Private placement of a certified registered security with the Postal Service as an indemnification. Advance payment to the indemnified party for its unpaid costs and expenses, such as liabilities, claims, causes of action, so that if they do bring a case, guess what? If they're going to bring a case against me, that indemnification clause to the SEC means they have to have the proper diplomatic channels of notice that a suit is being filed and that there are going to be costs and expenses to one party or the other. Who's going to be best able to mitigate it? Myself or them? Me. That's why it's important to do your due diligence. You better damn well know what you're doing. Obligation to defend. For the indemnifying party, The obligation to defend consists of both reimburse paid defense costs and expenses. Reimburse paid defense costs and expenses. So I'm using the full faith and credit. And I am supposed to, as the indemnifying party, defend. And when I defend, known as the creditor, they might have a little bit of a problem. Make advance payment for unpaid defense costs and expenses. Again, there's that make advance payment for unpaid defense costs and expenses. So it's sitting there in private escrow under full faith and credit, and all you have to do is access the credit. It's got a number attached to it for a number of credits. A right. You have an obligation with two elements, and you have a right. The indemnifying party has the right to assume and control the defense of the third-party suit, not some attorney underhandedly swiping everything from the estate. The obligation to defend is broader than the obligation to indemnify because it applies regardless of the merits of the third-party suit. This is why you have to bring your merits, the spiritual credence. The allegations of the lawsuit trigger the obligation to defend, not the ultimate disposition of the case. That's why when you go into these courts and that lawsuit has been triggered and they have you come to a disposition hearing. Greetings, tribe. How you doing tonight, brother?
Greetings and salute to you all. Good to see Stephen here, and good to see you. And it sounds like a great topic you're going on here. I want to mention that a lot of the things you're bringing up here about the estate and your all caps name, so to speak. One of the things that a lot of people forget is that what's created in that, a lot of things we can't access that we talk about here, because we talk about it, we know it exists, it's been enumerated. But as you know, it's just practically difficult for anyone to liquidate or access those funds. However, it did create something called a sole proprietorship. And that sole proprietorship is still something that you can control. And believe it or not, a sole proprietorship can move into a Chapter 11 bankruptcy as the debtor in control of the estate, doing exactly what you just said right here. In which case you would have basically precedence with federal law to be in control of all assets, including causes of action, claims, legal claims,
Right,
which against you or for you are considered part of the estate, in which you as the debtor are in control of if you choose to be, because you cannot be a minor in control of an estate. You have to be a majority and make a statement as the positive of such. But this is not legal lawful advice, just my opinion. Don't do this.
Yeah, well, and we'll find out that that indemnification agreement, that's actually ends up being an asset, okay? And as an asset, it's unliquidated for its value. So that, and that's what happens. It's you liquidate it upon a claim.
Well, here we go.
That was what I was curious about, because you're saying it has to have prepaid payments. How are those payments stored? Are they stored in a bond? Are they stored in a
right? It's like that. It's like that agreement we saw last week that the guy said 1,737,000,000 whatever, and he had it set up in 4 different bonds and at different amounts. And that's why I want to get a hold of the guy so bad. I want to find out what that is. I think it's one sits at the municipal, one sits at the state. One sits at the county, one sits at the state, and one sits at the federal, and then you have your indemnification that sits with the Postal Service, saying that that has been registered with the SEC.
So, in a practical sense, Wizard, I could tell you this, at least on this state, if you're going to do such a thing, let's just say hypothetically it was against a mayor of a municipality, and let's just say that they did something that was reason or cause for you to seek redress of the grievances, right?
Right.
This is probably one of the most underlooked First Amendment rights. Everyone talks about 1A auditing and this and that, freedom of speech, freedom of religion, freedom of assembly. But when you really get down to it, these are only secured rights. They're natural rights. But when you say they're natural rights, why would you even need to express them in such a way as being anything but being protected? They should be something that you should naturally want to do, and it should be unnatural to not have them protected. That being said, before I get lost in that, the reason for petitioning, the reason for petitioning redress, the reason for assembly and such is for the purpose of seeking redress, right? The correction of wrongs. And ultimately, the purpose of a redress is reparation. And the definition of reparation almost always includes money as the reparation. So therefore, it's a constitutionally secured right, security. And in this fact, the fact that you have people, right, men and women in positions as trustees of the governments, various public bodies, that they can violate people's rights at will because they're people and people make mistakes. However, when they cause loss, injury, and harm during the official course of their duty, it would seem to most reasonable people, right, that somebody has to be held accountable in the governmental level. That would become, hang on one second.
Yeah, real quick while we're waiting for him. Foreign Representatives, Chapter 15, non-main. Your expletive creditor. This is Chapter 15 bankruptcy. This was brought in 2016, and most people are not familiar with it yet, but Chapter 15 is cross-border ancillary bankruptcy cases. And he's got Chapter 15 is less than a full bankruptcy. It invokes a stay until your plan is accepted because they recognize it's a cross-border and may have differences. You have diversity of suitors. That dead sheet ain't mine, and I don't necromance. Absolutely. And it's related to the Department of Homeland Security redress through TSA, yes. Transportation Security Administration. That's the Homeland Security redress. So
at the federal level, yeah, it's probably a little bit clear, but back to like a municipal level, like a mayor, for instance, just as a hypothetical, Wizard, not saying anything. This is just an experimental, creative experiment we're doing here, right? But the redress, right? It means really that, you're retaining a right to petition the government for redress for any interferences with your freedoms, right?
Right, and you're putting something forth that is, it's just like a declaration that, hey, it's a warning here. I'm kind of special. If you do something, you better check here first. This better be the red flag that pops up first every time.
Exactly. Yeah, you're petitioning for redress of grievances because, and listen, here's key, and here's something that you've been talking about for the last few days, and this is where it makes that nexus. And I hope you're listening, Steve, because this is what you're looking for right here, is that petition to redresses of grievances must have adequate surety in order for the reparation implication to have any justifiable meaning. Without means of providing that payment, right? That reparation money for the actions of the party, then the right to petition to redress would have no or little value, right? So
Absolutely.
they can't in any way, it would be a worthless set of words contrary to the authors of We the People, et cetera, right?
Well, and I think that's part of the problem with the Constitution is people don't read that Constitution and know it well enough to understand that, like you said, it's a money security. And in that First Amendment is what's securing your right through that petition of redress to be compensated. But people don't see that. They see that as their right to go out and protest.
Exactly. And the protest is just to bring the grievance forward, period. What you were just saying. It's bringing it forward. Once it's forward, now it's up to risk management and the other insurance agencies, Stephen, right? So each town county, township, village, province, borough, valley, range, state agency, government-sponsored organization, government agency, government organization, division, department, and the like, right? All of them are required to have insurance, not because of a statute or a vague principle, because of the guarantee that should harm befall on one of the people or their posterity, of which a petitioner happens to be, you and me, right? There must be a means whereby they have the right to be compensated via reparation.
And that's what a lot of your insurance companies will do too, as far as auto insurance. A lot of your insurance companies, if you're paying a good price, they're going to allow for uninsured motorists. So you're still, covered. And that's what this indemnification is about. What I'm saying is it's an asset that you can place, and it shows that your word is your bond. And that's an asset. It's got value. Put a value to it. Let them liquidate it if you need to.
Well, I think there's a couple ways to understand it too, in that you can indemnify the transaction or indemnify the contract.
Right.
So
well,
you have multiple transactions.
Right. They're indemnifying the period of the contract so it comes to completion, and the payment of the contract to make sure that the contractors get paid. We're kind of on a different scale where we're per contract to make sure we're not harmed, and that if we are, then we get paid. It's the violations is what's going to impel the contract. The contract's just sitting there vacant at the moment. It's just an asset. But as soon as a violation, now it triggers that lawsuit. Now we have an obligation to defend. What can they do with that? They can't deny us our obligation.
Right, because here you got evidence of, Wizard. You've been damaged, right? Your property's been damaged. You've been misinformed through their misrepresentation and or misinformation, right?
Absolutely. 94 fucking cases. Had I known that that's what they were doing, was converting the name, I would have at least asked them about it a lot sooner and said, hey, I'm not a firm. Where are you getting that information? Or, hey, if you really want me to invest, I can see how I can make money on this. Teach me. But they don't do that.
Well, and then that's back to how you've been damaged. Their failure to act and or a failure to inform or failure to prevent. And you always think, it's only you got to bring a claim, right? Because you were denied the right via your various gatekeeping, municipalities, board members, council members, whatever there are there, right? All their different little practices. And, it's all back to malfeasance, right? Their failure to prevent, their failure to inform, and their failure to act.
Yep. And here, hold harmless provisions. This is, when I read this is what tied it in to the C.O.W.A.R.D.S and equity. In equity, I firmly believe it's the defense is a C.O.W.A.R.D.S, which is a bring forth the record. We're not coming against your title of the office. We're coming against the record. So we're going to indemnify and hold you harmless, but you got to bring forth that record. In that record, that's where the problem lies. It's in the words. It's not in their actions, because they're dependent upon the words. Fix the words, and their actions will change. Most indemnification provisions require the indemnifying party to indemnify and hold harmless the indemnified party for specified liabilities. In practice, these terms are typically paired and interpreted as a unit to mean indemnity. However, in some states, the phrase hold harmless may require the indemnifying party to advance payment for covered unpaid costs and expenses, even when the defined recoverable damages are limited to losses. If the hold harmless obligation is omitted, the indemnifying party does not become responsible for losses until the indemnified party makes payment. In addition, the obligation to hold harmless may release the indemnified party from any related claims or causes of action by the indemnifying party. So what you're doing is you're going to release them of claims so long as they help you hold their subordinates liable. It's not a way for them to get out of it. It's a way for them to, hey, we'll throw this guy under the bus and save our ass. But from now on, nobody can get tripped up, so we have to throw you under the bus. It's a way to get the principals to start doing their job finally. Because if they do it too much, you can go after them. You can remove the hold harmless.
Well, it all comes down to your redress, right? Which entails just compensation and reparations. And that's identified in the First and the Fifth Amendments. And it's not just about it being the Constitution or a national constitution, right? That it's the will of the people, that the founders, whatever you want to call, for the posterity, right? And the sovereignty of the United States of America, that Constitution for the United States of America, the 9th, the 10th Amendments, all of it implicitly stipulated that the Constitution applies to the states. So whatever they try to pull at the state level is still superseded by your constitutionally secured rights. And further, no one's property can be commandeered, seized, captured, or taken without due process of law. And that includes your secured rights. Due process.
And it has to be by necessity for the Army or the United States.
Well, yeah, but remember
not the state.
Right, exactly. But the point is that your secured rights are held as property, individually and collectively, right? Your secured rights. And nothing can be taken without that due process of law, either individually or collectively, of secured rights, anyone's or yours. It can't be done by the government. And for that, it has to be, there's just compensation due, right? Whether they take from you, when they take from anyone, it's taking from your rights. We've heard before, whenever you give up your rights, it's affecting my rights. Everyone needs to stand for their rights, because that's the whole responsibility. I mean, the presumption is that, the grievances, right? These redress grievances we have, that's our First Amendment right, implies the right to be compensated via reparations. It means that whatever official party violates the rights of another, right, that the people or the posterity, which is us, is clear evidence. There's no implied immunity, no qualified immunity, and no absolute immunity. Or if there were immunity, that would mean that there was complete indemnification, right, for which no public official in the United States possesses, right? So why do they have insurance?
Exactly, and that's what I was just going to say, because insurance comes by, and it doesn't make all parties whole. It only compensates, and this is the problem. This is the problem with insurance, is that people get insurance, and what happens is insurance, you have no rights. It's the insurance company that does the controlling of the suit and settling. Indemnification, it's telling us you get to control it, though you have an obligation to defend, and that's why I say you better know what you're doing. Because again, you're not going to defend it in a court. You're going to defend it in the documents. That's the true court. It doesn't happen in a public forum. Again, those are corporate courts. You're not being sued in a corporate capacity if you're providing private placement indemnification. It keeps it out of those courts, but maintains arbitration and the indemnification. It says the indemnifying party's obligation to indemnify is limited to recoverable damages caused by, related to, or resulting from covered events. So it's the event that causes a liquidation, and that liquidation is limited to the cost of that event. So they can't come after you for more than what the event was. Covered event. Go ahead.
I was gonna say, getting back to our whole Constitution and what they call the founding fathers, but they're really if you want to look at it, they're really the grantors of the country. The Constitution is part of the trust, right? And if you look at the grantor's intention is the law. That's the trust. That's the Constitution. So in trust law, the grantor's intention is a fundamental principle that determines the validity and terms of a trust, right? The grantor, also known as a settlor, is a person who creates the trust and transfers property into it. The grantor's intent to create a trust is essential, and it must be clearly manifested. This intent does not necessarily have to be expressed using specific words like trust or trustee, but it must be evident that the grantor intended to create a trust.
Yep, and that's the preamble to form a more perfect union.
That's it right here. That's what that's what I'm on. The grantor's intention is key element in establishing a valid trust, and it is governed by legal principles. Principles don't need to be proven, and requires within trust law. The requirements within trust law. So that's essentially what you were saying there. Is that within the preamble, and it's not just that anyone can be held where they can be not held harmless or what should be such, but people need to be compensated because people make mistakes, and when they do and they cause loss, injury, and harm in the name of this or in the duties of the state handling the trust manages that by compensating you, right? So the trust, the United States of America, holds bonds in those various capacity municipalities, capacities, bodies, entities that I just described, and it's up to you, I guess, to choose which ones are worth going for. Does that make sense? Which one has the right value for your amount of reparations needed, and then articulate it through the proper legal means, however that may be. Of course, we don't give that kind of information here because what we know, we're just doing a simulation experiment, right? Educational
legal means are literally just the words of the contract. If the contract says that you can be reimbursed or addressed with this by this manner for this cause, then that's your legal means. You don't have to go. The bottom line is the contract is your law. Whatever you're submitting to in the contract, that's your law. And as long as you have provisions for redress, then any reparations, restitution you're looking for should be addressed in the contract. If it's not addressed in the contract, then you have to come outside of the contract. But if the contract is properly written, then there should be redress and restitution in whatever means at which you could be harmed addressed in the contract. And if there's not, what you're supposed to do as the creator of the contract is allow for some type of remedy, even if one hasn't been addressed. So, you run in a mining company and you're all set for black lung disease, but turns out there's also radiation that's down there. So you didn't have that provision when you started mining because you never went that deep to get next to radiation. So as long as you adjust that contract to compensate for the now radiation exposure, in addition to black lung disease, you've done your part in making sure that there's restitution and reparations for whatever party inside the contract. So your indemnification, from what he's presenting here, looks like it's the best way to put it all together beforehand. So you can adjust it if need be, because you've already got a provision for some type of restitution reparations in your contract, even if you don't address all the different causes of which injury can occur.
Right.
That's what I'm interpreting.
Right, and that's what this is going to cover right here. It says covered events are specific types of events that are listed in the indemnification clause. They can vary according to the particulars of the transaction and are subject to negotiation. It's always negotiation. It's arbitration, not court litigation, arbitration. The most common covered events are breach of contract, negligence, bodily injury or death, and non-compliance with any laws. So this is where you have your set up, very simple terms here, but then you can have a fee schedule, and on that fee schedule, That's where you have fingerprinting and picture taking and anything like that they would do to you against the law that you could use with penalties attached to them. That's what those fee schedules are all about. We've been seeing those go in and out all over the place, all kinds of people pulling up all kinds of fee schedules, but they don't ever tell you how to use them. And that's because most of them don't. They just think it's fancy and they think it's going to do something. Again, the paper is not going to do the work. You have to.
Well, I'd say this is that the fee schedule, it doesn't really matter. It's what's damages are done. If you could just quantify that, the bookkeeping can be done at any time.
Right. And that, I'm just pointing out that the fee schedule is one of those things that you could use in an indemnification contract.
Sure. I mean, we could get into details about different ways of doing that, because there's a lot of different kinds of tactics as far as that goes. With that being said, I think the underlying principle that once you're harmed by people that are not performing their duty under the trust, which is the law of the land, that preamble is the highest one. If they're violating that first, that's a cardinal sin. No public official, public servant, any of them can be violating the public trust to that effect and not be held accountable within a way to be redressed. And that's that's where that comes in, is that the fact of the matter is there's huge industry built around those bonds, and that because there's no way you're ever going to get those damages. Even when it comes down to the mining company, if they're indemnified for black lung and then they find radiation, even the radiation claims would bankrupt the company many times over. How do those people get money, though? Ultimately, they're going to have medical problems. The government's going to take care of it, right? Because the government is the one that registered that company in the first place. You get it? So there's layers to this that are not being addressed when you just look at one aspect of it. And Wyzard's really good at digging deep. And I know a lot of people don't like it because it's very complex. And let's face it, Wyzard, sometimes it's hard to get people to stick along with the attention to do this. At the same time, we both can get frustrated at times expressing it, and we can be dull and boring to some people or overly hyped and exuberant.
Yeah, I admit it is dull and boring. It is, but some people, you just have to understand how important it is. You got to grow up and learn that, hey, life isn't always just fun and joy, and sometimes you have to take some deep study to get some things down pat to protect yourself.
Well, all right. So here's some things. I don't find it dull and boring, but I'll yield for a second. What was that, Stephen?
Well, it was 5-speed, but I was sitting here. Yeah, I was sitting here listening to you two go back and forth about this stuff, and I can see how society would be overwhelmed trying to figure this stuff out. And it almost seems that all of these writings and these codes and policies and procedures and everything has been used in a manipulative way, and that's the foundation that they're built upon, and may not have any purpose at all to life. Well, just a thought, I sit here, what ought be done shall be done. There's nothing new under the sun. So what's all this paperwork we got to hold down, and all of this business license and all of this shit?
Absolutely.
That they got to track.
But it's all, so to me,
you see how the common people that are just coming into this would be overwhelmed with all this, Steve, and it would feel like that they don't have a chance in hell of figuring out any of this.
They don't have a prayer. So that's kind of where I kind of try to translate this stuff, because the regards of understanding, we all go through insurance and things for it, but to understand indemnification, to me, to water it down, to make it simple, they teach us business, which is everything that's incorporated inside of the incorporation. What we need to know is commerce. And when we learn commerce, things like this indemnification clause is essential for you conducting any commerce.
But commerce is when two people come together, regardless.
Correct.
And it's the careful to maintain good works and equal consideration with equal benefit.
So
right,
but true commerce is common sense. I do
Right.
unto you as I want unto myself. Now, how specific we want to get down to titling that is up to us.
Well, we shouldn't have to dig through a bunch of history lessons and paperwork and policies and procedures and codes to figure all of that out.
Well,
It
unfortunately,
should already be inherent in us.
but that's
Well,
the whole waste of school. That we're wasting basically 3 years of school teaching a bunch of shit you don't need to know.
And on top of that, we're also not being taught the spiritual concept of that redemption or indemnification, in the fact that you really don't need, again, that monetary system. If we went back to the ancient times, I believe that if a man caused harm against another man's family, he would compensate that family somehow by becoming an indentured servitude for a period of time, doing certain tasks that would alleviate that from that family, and thereby compensating them by his labor.
Or anything to that effect. You can, I got 3 trucks. Go ahead and take one because
exactly
one of yours. Just common sense. Just, hey, let me do right by you. If I help you, let me do right by you. But that the bottom line is that they've created a vast, unbelievably diabolical infrastructure that is overwhelmed with a bunch of process and procedures that do help, but it's overkill. And it's there primarily to confuse the shit out of the public. So as long as we're confused and we don't really understand what's really going on, we get confused from doing business to commerce, back to business, back to a new contract. It's so many layers of contract that they're putting on us when you could get it all done with one. And keep the concept simple. You don't have to have, 45, 55 rider clauses. You create the stuff as you go. That's what a good contract would be. Is a good contract is hey, you and I are going to do business together. And with us doing business together, I'll protect you. If you get hurt, you protect me if I get hurt. And then you have a way at which you do that. If you run into something, like I was saying, you run into radiation and you were already prepared for other things, but now you ran into radiation. You got to just create. The NFL did this with head injuries. It came out that head injuries were a true claim. They opened up an entire department for head injuries when originally there was no department for head injuries. When I played, it was just shake it off. You just got your bell rung.
Yeah,
and that's
like I said earlier, it's negotiable. They're negotiated by the parties. It remains a negotiation all the way through. And it says the principal categories of recoverable damages are losses, include any covered judgments, settlements, fees, costs, and expenses. The indemnifying party becomes responsible for a loss only after the indemnified party pays. Liabilities. Liabilities are composed of debts and other legal obligations. The indemnifying party becomes responsible for a liability when the liability is legally imposed, but before the money is paid. This is the thing with the indemnification on the private side as a private placement. It sits there as a prepayment. You can maintain your obligation to the suit, and you can maintain your obligation to the liabilities of payments, but they can't come at you for them. It's already done. What is done is what ought to be done. It's prepaid. Claims.
Yeah.
Go ahead.
If I could interrupt just 1 second, I won't go on, but just what 5-Speed was saying is that there are some, you're not bound to go into commerce. And this is kind of the thing that people get wrong, is that, we still have trade, and there's merchant law. There's other things besides commerce law that you can be engaged in for your normal day-to-day functions, including money exchange, etc. goods and services, and your trade, your occupations. None of it's bound by the Commerce Code. Once you get into commerce, then you're bound with all the complexities of taxes and things and such like that. Not that
But
we're talking about that.
But wouldn't you think all commerce should be for the good of humanity?
No, it's commercial. It's done
No,
for
well,
international.
And that just gives you the two-headed snake right there to be deceitful. I feel.
Well, you
Well,
don't
yeah,
need to
and
be part of it. That's the
yeah,
whole
and that's why I
point.
say that's why I say we don't need to be part of that.
That's
And if
right.
people would recognize this sooner, they'd just be putting up indemnity clauses. There you go.
What all be done shall be done. There's nothing new under the sun.
Yeah.
Now, if I brought harm, please.
So here's the thing, though.
Yeah.
Here's what's established with commerce. When you get to the magnitude, the scale of what Stephen was talking about, like a mining operation, right? You're extracting minerals from the ground at a large scale. A lot of risk involved, a lot of lives at risk. And if something came to the effect that you're only worried about black lung, something that shows up years later, maybe, right? That could be spread out over many, many years or decades. All of a sudden, there's a radiation risk, right? This is something at orders of magnitude, much more happens immediately, and it happens with a big public backlash to your company, your stockholders, and it causes a huge amount of medical claims instantly. It bankrupts a company many times over. And when it comes down to it, the people that are injured by that act of commerce, right, will never get that money from the company they worked for. Where do they get it from? The government is going to have to give it to them, because the government, it was a creature of the state in the first place that injured them. You get it? Because it was registered under commerce. So you see, the purpose of commerce is really so the government can kind of step in there when things are of such a large operation. They may find some way that it keeps a national security at a level we never think about, like mineral extraction. And if it does harm the people, the government has to be able to step in if the private operation can't, because they're a partner to the corporation as a matter of being a corporation, LLC, et cetera, et cetera.
Again, I get certain things need to be private, but I think more things need to be open. There's been enough secrecy.
That's what trusts are for, isn't it?
Yeah, you got to understand your privacy has to remain private. There are certain things that need to be public, of course.
I'm talking in government's eyes, not the people. I'm talking government.
That's the thing, though, is like if you're talking about a mining company or the NFL, these are public. Well, the NFL's not public, but a mining company usually is public, because that's going to be protected by the national corporation, because it has to cover, because that's a resource. And because it's a resource and the government's buying so much of that resource right out the gate, they're going to come in if they go to a situation where they got something that would be catastrophic to the business. So they'll come in with regulation to aid that company so it doesn't go under, because it was a peril that they didn't see when they originally commissioned the company to go and get the resources in the first place. So there's mechanisms inside, but the bottom line, what I think Keith is addressing here, is that we can start out with an indemnification for whatever contract we walk into. And so you want to sit here and say, oh, I owe you this, I owe this. Hey, whoa, hold up, partner. When I jumped in, I had an indemnification walking in the door. So you don't have to worry about suing me. I've already got that ready. So here's something that you could go right to. I already addressed it. Didn't know what the problem was going to be, but now that we got one, I got a provision already in place to manage any claim you may have. That's how I'm seeing this.
And this goes for if you want to go get a license or then turn around and go get a job or open a bank account. That indemnity is for every situation in your life, because contract and commerce permeates every aspect of your life now. Everybody goes and sends their kids to a public or private school instead of teaching them themselves. Everybody goes to church. Everybody's voting. It permeates almost every aspect of everybody's life.
Anywhere that name is.
It's meant to. So learn that. and understand that just learn how to present the person for its aspect that he's supposed to be supposed to be presented as, and that is it gets no respect. It's the one that gets beat up. It's the one that gets taken away. It's the one that gets its money taken, not you.
Designed for it. It's designed to get its ass whooped. It's designed to get to be the first one on the ground and the first.
That's why they call it a straw man. You can beat it up, beat it up, beat it up, beat it up all you want. It ain't gonna get hurt. It's gonna lose some of its straw, maybe.
But you can stuff it with more straw.
Exactly. Claims. Claims consist of damages resulting from third-party lawsuit. The indemnifying party becomes responsible for a claim at the moment when a party, including any third party, files a lawsuit. This is what's happening on them. The indemnifying party, the surety company, becomes responsible for a claim at the moment when a party, including any third party, files a lawsuit. So we go to the surety company and file a claim with them. That's going to trigger their indemnification against whoever's bringing the violation.
Briefly, Wizard. So take note. What you're saying is what needs to be done, how that's actually done, and how you create the evidence to bring forth to bring that cause of action reliably in the court without dealing with their presumptions is yet to be discussed. So
well, you're not taking it to the court. You're taking it to the surety company. The surety company.
I'm sorry. I'm spoiling it. I'm sorry. Go on with where you are, but I'm just saying there's a whole bunch of other steps up to this point here to get this on the record. But yeah, continue.
No. As long as you've got your ass covered with that indemnification bond and you're recognized as the third party because they're already in a contract with principal and subcontractor and they violate you, you're supposed to, as far as I know, my research says, again, those are Article 1 corporate courts. We as the people are supposed to go to the surety company and make a claim, and they are required by federal law to do an investigation themselves. Not the courts, not the police, not the DA, not the surety company itself.
Right. I wouldn't rely on that. I'd say that I'd put forth that, take care of the necessary affidavits and such. I'd tell them, look, the right to petition for redress of grievances guarantees the need for the right reparation and the correction of wrongs. Right.
Right. And that's private. And that's private, not in public.
It is within the authority of the court to do so. So the insured has a bond and or surety, right, which is placed to protect individuals such as myself, who should bring forth a claim of violation as delineated in the law. So that's why it's in the courts. The insurance company has policies and procedures that are required to be followed under the McDade Amendment principles, and the court has the authority to order them to follow that policy. Okay, you get that? The McDade Amendment. So that's what is going to give a force, some bite to what you're claiming here. You know what I'm saying? I'm not saying you're not right. I'm saying you want some bite.
I'd have to look at that more. You evidently have more research on that than I do, but I have heard of the McDade thing. But
I'm expounding on what you're reading here because I'm giving you you're giving the outline, the 10,000-foot view of what needs to be done, and this is on the ground where the rubber's meeting the road. What you have to do to go forward, because what you're going to be doing, right? You're going to be bringing forth a claim against their bond and other security via adhesion, direct culpability, or liability, and against the insurance company for the wayward act of the insured.
Yeah,
that's what you're doing ultimately. So you want to establish that, right? And then you're going to contend that you have the right to receive information and to file a claim under your right to petition for redress of grievance, which you've never waived.
And this is the main point that I think it's helping with is when you place that indemnification, it gives you that notice of the cause of action. They know that you now have a cause of action for anything they might do. Otherwise, I think that's why they just go ahead and try to bully everybody, because they know nobody's got these bonds and everything taken care of. So unless they do, they don't have a real cause of action most of the time. Says the indemnifying party becomes responsible for a cause of action when the indemnified parties or a third party's right to seek relief, as the case may be, accrues. The phrases, the nexus phrases caused by, related to, and resulting from are referred to as nexus phrases. Nexus phrases link the recoverable damages to the covered events. Now, if you guys don't understand, I've been spewing all along, it's all about the language, and you better start learning that language so you learn how to condemn it. These phrases are typically negotiated by the parties because they either broaden or limit the obligation to indemnify. The indemnified party typically wants to use a broad nexus phrase, such as related to, because it expands the scope of the indemnity. The indemnifying party prefers narrower nexus phrases, such as caused by or resulting from, because they narrow the scope of the indemnity. What are the common exceptions? There are a number of common exceptions to indemnification. And this is where the first duty of law is legal notice comes in at play. Because once you give them notice and they neglect to follow up, it is now negligence or gross negligence. Improper use would be the same thing. You can't require me to have an ID. There is no law that says I'm to have one. Therefore, you just asking me for an ID and me telling you I don't have one should give you a clue that maybe I'm a third-party benefactor. Bad faith failure to comply with its obligations in the agreement. You took an oath to the Constitution. I didn't. Again, I'm not the party you think I am. Common formulation for the negligence exception is the indemnifying party is not obligated to indemnify the indemnified party for any claim arising out of the indemnified party's negligence or more culpable act or omission, including recklessness or willful misconduct. And you can search up indemnification clauses too. Find all kinds of them and draft them up for your own. Convert them however you need to. It's important to start learning this stuff, folks. Indemnified parties with a lot of negotiating power may seek indemnification for their own negligence and insist that the exception apply only to gross negligence. While this is not against public policy, it is unusual in commercial contracts and is typically limited to certain industries such as construction. Any questions on that?
No, I think the whole thing is learn how to construct the claims, right, for that indemnification to go against that surety, right, the bond, the insured. Yeah. So again, you got to do something, whereas you have to make an affidavit. I hereby request as my right compensation, right? So you want it in the form of what? Full limitation of the jurisdiction for the total value of your claim for each of the defendants you name, right? Individually, severally, and independent. So that's probably the best way to maximize a claim, right? And their separate capacities as is cognizable by law.
I was going to say, once you got the whoever holds the bond find out their process for claims, they have to publish it.
Well, yeah, but you're going to present that affidavit and attach it with your interrogatories to the, on public record in the court of record. So without establishing, stating, or bringing forth any presumptions or argument, right, against that they conclusively said that you waived any rights that you knowingly and intentionally did, you didn't, and that no one has an authority to take away that right to make the claim, and you present your affidavit on the record. I mean, the whole thing is once you give the interrogatories, they're bound by law to answer them. So well-constructed interrogatories in a court of record means that all this becomes public record.
And that's why.
Case, are you talking about a particular case here? Or are we just speaking in general terms?
Well, if you're going to make a claim on their bond, you better have some evidence on record.
What brought you into court is my question. What brought you to court?
You were
Are you
injured.
talking about a case?
Well,
Because-
any kind of violation they might bring against you, you have a cause of action.
I wouldn't have a judge. I wouldn't have a court involved, personally.
No, that's
Because-
what I'm saying too. But you would still have a cause of action. But again, he's absolutely right in that, because their presumption is still that you're a corporate entity.
Right, but when you go after the bond is what I think you're speaking about. That circumvents the judge, all those positions. Remember, they're fictions. They're actors. So you're going after their insurance policy, basically, and the judges and stuff aren't involved in that.
Well, you're trying to settle the matter before any public venue. So
that exactly.
You're trying to settle the matter before there's anything. So you're trying to stay private and say, hey, I've reviewed your process and procedures for claims. Here's my claim. I'm giving you notice, and I will use this notice if I am unable to settle this with you before going to a court or arbitration.
Correct.
Exactly. And that's formed through the trustee and that indentured trustee on the claim, on the bond.
And that comes from Matthew 18, verse 15. If you have aught with your brother, go to them in private.
Always.
Right, but we all know that you go to them with your complaint or your video, you'll get nothing. And if you go to them with a judgment in your favor from a court of record, they're going to honor the claim just like anything else, because you're bringing forth evidence. You know, you're simply bringing forth your claim as stated, right? And you're exercising your right to petition for redress of grievances. Because remember, it was the government that did this. There's no private anymore, right? And your right to petition for redress was hampered, hindered, blocked, or denied without your due process of law. And as a result, you had a right to file a claim against the insurance bond. If you don't go through the due process first, you don't get the right to file the claim. So you're going to go through the due process. Now you have a right to file the insurance bond if you don't get a judgment in your favor to begin with. You get it? Because it's all on record now.
You get it wrong.
That was all of those.
You have to be the one creating it. You're the creator.
And that's where we're different, Tribe. I don't know if you were here. We're talking about securitizing that indemnification agreement as a contract on the private side, which is a private placement after being registered with the Securities Exchange Commission. They'll give you a certificate certifying that it's registered. Now you can put that certificate with the indemnification agreement in a private placement with the Postal Service for all contracts related to that estate.
Everything securitize that bond.
Yeah, everything now has to go through the Postal Service, not the courts.
You make a security out of it by endorsing it. That trumps law, the judges, the lawyer, every single body that's charging to your birth certificate does away with them.
That is your contract, which is law, and it's a contract of law that plays with all other contracts. It's an indemnification contract for the utility company, the phone company, the local municipality, the county courts, the state courts, the federal courts, the international forum. It's an international customs bond. It's been customized.
You're the creditor. You're the one giving it. You're the one designing it. So that's why your word keeps on pounding words. Because when you form A, okay, I'm going to Form A contract. That's my Form A contract. Well, I'm forming it. I better know some words, not tricky words, simple words. But you're forming a new contract with them. You're actually fixing their language. And I use part of their contract always. I just change a couple things, and the answers are always in them.
Maybe I'm a little confused on what the problem was. I just know that there was an issue where someone was harmed by a municipal public official, so to speak, and there is a way to get redress for that. And we're discussing ways to actually access that monetary reparation. So, you could go directly like that, but chances are, once you do find out that information, that there's really no evidence on the record that compels them to pay out a claim. Whereas if
Well,
you have a judgment
and that
or a court to compel them,
no,
then you have a little bit more leverage
no,
to get that claim.
no. Again, if you're not understanding, the indemnification agreement allows you to control and settle. They cannot control and settle anymore with when you bring forth an actual indemnification, which is not a surety and not a insurance. It's a surety bond with a contract. And that's what you're doing. Nobody's doing these bonds right. These birth certificates and authenticating. That birth certificate is already authenticated. That's what the seal is. And then they want to act like an idiot and have it sent back to the state to have them authenticated. What don't you accept about the full faith and credit in the seal? All it needs is a contract. Contract it, put it in its right place, make sure it's got a fee schedule attached.
You're the only one. You are the only one that can authorize their bond. Remember that always. You are the only one that can put value to it, and your value comes from. It actually takes gold and silver and minerals for you to live, and for me to live, and for everybody. It takes sunshine and all the heavenly beauty we have. Well, that is your tie to this security, to all the wealth, and we are takers with care of Mother Earth. Well, I'm not showing you shit. I am the man. I am. But you give them authorization on that bond. You're the only one that can, and that bond is in place for their insurance not to harm you. So anything they do against you is a harm. Copy the bond, and you endorse it, and you stamp
good luck. Good luck getting
I've
them
done
to enforce it. Is all I can say. It's a stretch, but good luck.
All right, we'll see you later, Steve. Thanks for stopping in. And then we'll continue on with indemnification method. Now, this is something I've been speaking about for a number of years as well, is this little term right here, swap.
Salute, Steve.
And it says, what is the indemnification method? The indemnification method calculates the termination payments when a swap is ended early and the holder has accepted an offer of prepayment. The indemnification method can be compared with two other acceptable termination or repayment strategies. Remember, they're talking prepayment and repayment. Why is it repayment? If I'm holder and I'm accepting prepayment as a termination repayment, is that saying that I paid something first? You got to think about this, which are the formula and agreement value methods. The term indemnity means protection against liability. So just by providing that indemnity, the bond and the agreement, you are protected against liability. Why would you need to go get an insurance agreement? That doesn't protect you against liability. What it does is it removes your rights. And now the insurance company will make the settlement and control that settlement. And then guess what? They're going to charge you more for that supposed protection against liability. That is not a protection against liability. They are now holding you liable for a greater amount. You are being held liable to make a prepayment and never getting a benefit out of it. That's a liability by loss of rights. If you don't know what's going on, I urge you to stop and learn it. Otherwise, you keep going into the same trap and then teaching your children that they got to do it too. The indemnification method requires the at-fault counterparty to compensate the responsible counterparty for all losses and damages caused by an early termination. And again, that early termination of that bond sitting there is that it's liquidated. It can be liquidated. It's unliquidated, and you can terminate it by liquidating it. That's what the cause of action brings in, and it's an automation of a process of generating those credits that were mentioned prior to needing them. This method was common when swaps were first developed, but was considered inefficient because it did not actually quantify or describe how to quantify those losses and damages from a prematurely terminated swap. See, this is what's happening in the background when you make that insurance payment or that fine payment down at the courthouse. They got all kinds of investors on the backside doing what's known as credit default swaps. And you're in default because you paid and you didn't use credit. It's a credit.
You did an improper transaction.
Right. You use money instead of credit. So they call it a credit default swap. They're going to bet on you. They're going to take out a 90-day insurance. And as long as you keep making your insurance payments, you're paying them and all their investors. And they're using your estate to do it as an investment.
They're using your birth certificate bond, your bond.
Yep.
They all have it open.
Every month,
That's
you're
why
issuing bonds.
You got to get that name. You got to show who you are. Take it back.
Today, the agreement value method. Agreement value method. Remember 18 U.S.C. 8? Stamps and other representatives of value. Does that sound like a different representative of value? An agreement value method? Which is based on the terms and interest rates available for a replacement swap, is the most widely used method for calculating termination payments. Another less common alternative is the formula method. A swap is an agreement.
That's for the taxes. That's the stamps for the fucking taxes. Nobody's paying the tax. They may turn the forms in, but they're not paying taxes on the documents.
Right.
That's what that 10-cent fucking stamp is for. Canceled.
And
taxes.
And it's supposed to be a capital transfer stamp, and that's what tells us that they're not actually transferring property. Not real property. They're transferring your rights. A swap is an agreement made between two counterparties to exchange cash flows. For example, fixed for floating, along with underlying currencies, such as underlying obligations. So the exchange cash flows is the same thing as exchanging obligations. Same concept. Or other securities, such as commodities, terminating at a predetermined date in the future. So it's a predetermined date in the future, usually 1 year, 10 years, or more. A swap contract may be terminated early if either counterparty experiences a credit event. Notice they didn't call it a money event. They didn't call it a cash event. They're calling it a credit event or default, such as bankruptcy or failure to pay, or a termination event, such as an illegality, tax event upon a merger, or other contingency, saying that the contingency has to be there. So let's take a look at what a credit event is real quick. Credit event is a sudden and tangible negative change in a borrower's capacity to meet its obligations, which triggers a settlement under a credit default swap contract. A credit default swap is a credit derivative investment product with a contract between two parties. In a credit default swap, the buyer makes periodic payments to a seller for protection against credit events like default. In this case, the default is the event that would trigger settlement of the CDS contract. Credit card means any card, plate, coupon book, or other credit device used for the purpose of obtaining money, property, labor, or services on credit. Do you suppose that officer is pulling you over for a credit event? I mean, they are using a card of some sort to obtain your money, property, labor, or services, correct? You think they're using their money to do that? Come now. Oops. I guess I should show you the page.
Yeah, they're trying to open it. They're trying to account with you. They're trying to form an account.
You may think of a CDS as insurance aimed at protecting the buyer by transferring the risk of credit event to a third party. What do you think the idea is all about? The authorized representative is giving an unambiguous authorized signature on the instrument, is therefore not liable for the person named in the instrument. So when the officer pulls you over and you sign on that instrument, you're a third person. There's the person named in the instrument, there's the officer, and there's you. You better learn this stuff, folks. So the next one we've got is, what is a letter of indemnity? A letter of indemnity, come on, is a document that guarantees certain provisions will be met between two parties to a contract, or compensation will be provided. Your officers will not communicate with me for any reason. If they do, you have to compensate me. It's called forced labor. You're trying to use your public policy, threatening to use it, which is abuse or threatened abuse of the law, whether it be civil, criminal, or administrative, for a purpose which it was not intended. And you, being the contract party with your principal, know that you're not supposed to be harassing the benefactor for any reason. These letters promise to make one or more parties to a contract whole again if a contractual obligation doesn't end up being fulfilled. So, again, it's a contract term that you agree to pay me, and that's part of the contract. And if you don't, then the surety company comes in with, I go to them with a claim now under that indemnification clause saying, hey, they violated the contract. They failed to pay me. I think I want double the compensation now, maybe triple. They're making me wait. For instance, in finance, in settlement, see how they babble? Letters of indemnification can be used to protect against losses from lapses in security, documentation, or procedure. Banks or insurance companies issue letters of indemnification to cover parties against financial losses from a breach of contract. These offer contracting parties some protection and greater ease when entering a transaction, knowing they will be covered should there be any losses from another party's failure to fulfill the contract. So we have a agreement, again, like I said, that I believe is supposed to be held in private placement somewhere. And I believe that to be the Postal Service, again, as the ultimate contractor, as a third party representative that's already named the registered agent.
I use the postal to create the security. That's what I, and then it also makes the Postmaster General and invokes him. But when you place a stamp on your document, and I even go as far as to put it on bond paper, I just reprint the document I have, create a security with it, endorse it, stamp it, and then when it's placed in through the post office, it becomes energized. Let's say it now it has value. And the stamp's placed on a document because the document is separate. So, and that's where my money on a lot of this comes from, is that security inside with my letter. Anyway.
And it says the role of a letter of indemnification is to ensure that one or more parties to a contract won't take on losses if another party doesn't fulfill their part. LOIs can be provided by a third party who insures the contract and assumes responsibility for any financial loss or damage. And that's what we're doing with that surety bond. We're taking that surety bond, which is already liable, and we're registering it in the proper place for a private placement so it can hold that indemnification liability. Now it's obligated to defend suits, not to be represented by a third party other than the one that's holding it. See, the holder has the right to enforce.
See, I use the UPUs because they're bonded too, actually. But I use their insurance over my documents, so I draw from their ass if something happens.
Well, they're the ones that originally fund everything. They're the ones that
I don't use my birth certificate for that.
They're the ones that hold the real estate investment trust. They are the electronic book entry system. They are the ones that are responsible to research and resolve any out of balance accounts with the general ledger within 3 days.
And that's why judges and all that stuff below are under all this shit, because they have a time frame there. They're not gonna let these guys slide down. They don't fuck that. They don't
exactly. That's why I say when they say you got a right to a speedy trial, that speedy trial in an Article I court that takes months, sometimes years, when the Postal Service has a responsibility to research and resolve any out of balance accounts with the general ledger. Well, the problem is it's an out of balance account with the general ledger, but nobody's recognizing it yet.
And we aren't. That's a big nobody.
That's a United States citizen you making a claim against. And that number you're using, he never learned how to use that number without the dashes. The LOI shields against liability, ensuring that the parties will be held harmless, even if there is a breach of contract. Indemnity refers to the full amount of compensation you would need to recover. As a legal term, indemnity also describes an exemption from liability. A letter of indemnity provides immunity from liability for one or both parties in a contract. So if I make a private placement contract with the Postal Service as the registered agent for the principal who I'm in contract with, namely the mayor, so that anything that happens on the local level, considering any kind of resident determination, that covers all the way from the United States all the way down, federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board, and every one of them has an address with the Postal Service.
Did they file a claim against you?
Who?
Or did somebody? The what you're talking about this?
No, I'm talking about correcting the record on the claims that they've already made that I found out that they're not supposed to be. Again, they converted the last name to a firm name. That tells me they're acting outside of their duties in all 94 cases.
On that trespass one.
No, this is in regards to my 8 years worth of research here about all them 94 cases.
Yeah, I just found out that one of my cases 8 years ago, which was settled in my favor, is still fucking open. So I got to go and close that one. But yeah, they stay open forever.
And it says with a third party often agreeing to indemnify against the potential losses. So I'm coming in as the third party. And as the third party, I'm the benefactor. And as the benefactor, I qualify for immunity because I'm a foreign entity. Diplomatic immunity at that. Understanding letters of indemnification. LOIs state that any damage caused to a contracting party is the responsibility of the other party or a third party to the contractual agreement. So my indemnification is that if I cause any harm to any of them, my surety bond, the third party, is liable. That's where you get the money. Theirs, all I got to do is make a claim on it because I've got that set up, that now you understand where my third party position is. It's the expression of a trust that they're already involved in and that you're the obligee. and they're the obligated party. Now, since they breached their contract, who they're obligated to the obligee and not the other contracting party, expressing the public service is a public trust. See, their
Okay,
surety bonds say that they're obligated to the obligee. That's me and you, we the people. The other people that they're involved with in the contracts are not obligees. They're contracting partners. Go ahead.
okay. So the question I have, just to kind of make sense for me, like in a when someone is buying an automobile or is renting an apartment. So well, let's say renting an apartment, a lot of times they have you fill out an application, but they show you a demonstration apartment of what your apartment would probably appear to look like, right? But then when they give you the keys to enter, the premises or the area that you're going to lay your head, it's usually different than what you're shown. So that would be constituting a swap in the type
No,
of.
that constitutes stupidity. I would never rent a place on based on that situation. No, I gotta go see it. And if you can't let me go see it, then you're not acting in good faith. That would be a bad faith deal, and therefore I don't want anything to do with you. People really need to start wisening up. This is bullshit. You shouldn't be doing that.
Okay, because that is the premise that a lot of these rental places, what they do, because I went and asked myself, and they goes, oh no, you got to fill out the application, you got to go through this process, and then we give you the lease. But then when you get the lease, it's all legally orchestrated with terms, and then you're in the front end, you're already put in app and done everything else. So they're not looking for you to really come back and say, now they're saying, now give me a report, if there's any damages, then we will take care of it. But there shouldn't be any damages prior
If
to.
it's a leasing company, they have a bonding agreement, and it's another insurance policy,
Well,
and
yeah, they
they're
all
doing
do.
harm to you.
And this is why I urge everybody, you better start learning contract and how to run those contracts, and understand that in good faith, you do unto your brother what you would have them do unto you. If they're doing something to you that seems nefarious, you should be thinking twice about even dealing with those people.
So then, Keith, would one have to go do the same process as you were saying? One would have to um, go after the bonding company, because in the event
Yes,
of the process that is doing, you are securitizing document, attaching your signature to an instrumentality,
correct. And
right?
that's what we'll be doing. One of the things here, I've got to get a hold of the landlord, the management company, so I can get the landlord's surety. That's one thing. Another thing I just thought of here not too long ago. I got to get the surety company of the management company's landlord. See, they're a management company, and we don't pay to the landlord. Yet that's what the contract says. And so there are things that we've got to get sorted out. Like I said, I made amendments. This rental agreement means contract or credit agreement. So they understand it's a credit agreement along with some other things. But just like the indemnification, it's negotiable. I can keep building it. And as I find more things, I've got to add more things. And those are just negotiations and in arbitration. We have the right to do that. And that's all we're doing is trying to make sure things are good and done in good faith. When we find something that's not in good faith, we have the not only just the uh, uh, right to, but the obligation to fix that ill faith.
So, Keith, then in respect to all of what you said, then the process would be, you would go not only after the bonding company, because some of the management company also would write, they are they are DBA to an LLC. So how would one handle that process?
You're still going to deal with the surety. So if they have an LLC, you can still get their surety based upon the individual people. They each have a surety. What is that surety? The birth certificate. And if they're not indemnified, guess what? They probably just lost their business. They better learn how to contract. That's why I say I'll come in and start taking over an LLC if I have to. Shut them down. You're not running good business. You're operating in bad faith. You got all these people you're renting out all these nasty, disgusting apartments to, and giving them a base rate apartment to look at and say, here's what you're getting. And then when they get there and move in, you fuck them, and they've got to be fucked for at least a month, paying for an apartment that they shouldn't even be in. Power of redemption is there, and I will do everything I can to do so. It's time to put an end to these bad faith actors, folks.
Yeah, because that's the process that they do, because I've seen it with my own eyes. And a lot of people who are indoctrinated, they really believe that is the process that they have to take going in to get somewhere to lay their head, because it's not taught. And I agree
Yep.
with you.
It goes on to say, for this reason, letters of indemnification are also called indemnity bonds or bonds of indemnity. So you have to write a letter. That's what it is. It's a letter with contract terms and conditions in it, explaining to them your position as a third party in requiring payment if they harm you. Are like insurance policies known as indemnity insurance. LOIs are used in various types of business transactions. In cases where items of value are transported by moving companies or delivery services, LOIs ensure that the party that owns the valuables will be compensated if the possessions are lost or damaged or stolen during transport. LOIs generally signed off when the valuable items are presented to the shipping company and before a bill of lading. It's like I said, it's just like a prepayment, which is a document issued by a carrier acknowledging receipt of cargo. They are also used when a second party borrows something of value from the first party, such as a car or a power tool. In this case, the person borrowing the car or power tool can protect themselves with a letter of indemnity. This would typically mean a third party, such as an insurance firm, takes financial responsibility for any losses or damage that might result from using the car or tool. Okay, in this situation, the car or tool is the identification. Okay? The third party, in this case, the person borrowing the car or power tool, we are borrowing the bonding instrument. It's not ours. We're borrowing it. Okay? As a borrower, we got to pay back, and we're going to pay them back double. What are we going to pay them back double with? The words that show credit, the words that grant, assure, and promise. That's all we're doing. They're the ones that already insured it. Like I said, that's an internationally protected person. We borrow it for its international protection. Write a letter qualifying what we know about that international protection and indemnification. Immunity. Whatever it is you think you need to put in that indemnification for whatever situation. LOI should always be signed by a witness. When the assets involved are quite valuable, it's preferable to have an insurance carrier representative, a banker, or another professional sign the document, not just any available witness. So when we see the ones with the Securities Exchange Commission fully registered, They're the ones certifying it. That qualifies as that second signature. I think that would qualify as the second signature. When are LOIs needed? Third-party liability. If a company hires a service and there's potential for damage or loss caused by this third party, an LOI can be used to protect the hiring company from any liability. That's what your letter of indemnification does. It protects you from any liability for any documents that you're signing because you're not fully qualified. You know you're not fully qualified, but upon demand of the government, in order for you to receive the benefit that the government is trying to give out, you have to sign it on that signature without prejudice, without recourse, paid to the order of the third party liable. Keith Orland Little, all uppercase. Does that make sense? Anybody miss out on that?
Okay, so you're saying that if there is an issue with the bonding company, you would create an LOI directly to them.
Correct.
Okay. And in
So,
that process,
so in our situation, the signature, technically, you could say you could when you have a child that's born in the hospital through that enumeration, just go ahead and provide an indemnification letter of indemnification right there for the Social Security number, and then when he grows up, teach him about that, and that should be just fine. But again, it takes learning about contracts and trust law and letting him know, teaching that child yourself what needs to be done with the documentation. And again, this is still a learning experience for myself. I'm not saying anything definitive. This is a process I believe is viable for the way I've researched it and the way we negotiate things. And by negotiation, if they're going to demand a Social Security number and a birth certificate so they can keep track of statistical elements, that's fine. I'd be willing to give them signatures for those statistical trackings, but they cannot use that against me. That's the indemnification through the Social Security. Go ahead and sign that card and send it right back to them with an indemnification. That card is a bond. Acts just like the birth certificate. It's in fact attached to the birth certificate. They just get issued by separate parties. So let's take a look at the next one. Remember that credit default swap definition. Swap definition. And how to calculate gains. Remember we talked not too long ago about selling these documents, and what happens is they get sent into two markets for two different prices. A swap is a derivative contract through which two parties exchange the cash flow or liabilities from two different financial instruments. This is why I say we create our own indemnification under that surety and we swap it. I'll take your 73 million and I'm going to double it. Now let's swap.
So
now who's liable to who?
If you look right in the word derivative, you see the word river, and that's where the flow the flow and the change of the process that they do through an indemnification, and that's pretty much what you're talking about, correct?
Yep. You're there. Like I tell everybody, everything's backwards. Everything's been swapped. Everything's upside down and backwards. Swap it. Turn it around. You have to turn it around. It says most swaps involve cash flows based on notional principal amount. That's that enumeration of birth. They granted that nationality. It's a notion that you'll be valuable up to this amount. Your mom and dad come from this kind of a background, according to the statistics. They did real good. They're kind of intelligent. Yeah, we think he's gonna be smart. We'll say he's gonna be a doctor. He's gonna make some good money. So we'll put a notional principal amount of this on it. It's just like a prepayment amount. It's a pre-calculation. That's all it is, such as a loan or bond. Although the instrument can be almost anything. Usually, the principal does not change hands. Each cash flow comprises one leg of the swap. Remember the graph that we saw the other day, and it showed the principal, and then they had an obligation, and then there was an indemnification, and then there was a surety. Okay, they're going to cover one leg of the swap. One cash flow is generally fixed, while the other is variable and based on a benchmark interest rate, floating currency exchange rate, or index price. One cash flow is generally fixed, while the other is variable and based on a benchmark interest rate. The principal interest has determined and assessed it to be 100 billion.
So Keith, let me ask you a question based on insurance. If someone acquires an insurance, say like they get one of those not the term insurance, the what the other one is called a full life insurance, right? And everything is included in there, included, and it's already fixed where there is some type of a derivative that is built up with that insurance. Once it's paid up, then that derivative is built up off of an interest rate, correct? So it just keeps building on and increasing with that interest. Is that correct?
It could be.
Because it
Depends.
because the reason I ask you that, I remember one time I heard some insurance guys talking, and they were saying that if you have insurance that's paid up, you no longer have to continue paying on it once it's paid up. The dividend kicks in every time, and so it just keeps. I guess it will just keep renewing itself. I guess I'm not sure, but that's what I thought I overstood.
That bill is the dividend check. That's what the bill is.
Right.
That's where the whole security fraud it comes in, because they give us our dividend check. We don't know. We think it's a bill. They take that and our payment, and they never claim it. But yet they claim that we know that we claimed it, and we didn't. So that's where the fraud comes in. That's why you go after their. It's basically like you're investing in State Farm. You're investing and you're not getting your dividend check. You're having to pay your dividend check, and they're getting both.
Yep, they're getting the full investment, which is the principal amount, their percentage amount, and your dividend.
And you're supposed to get the principal back and the dividend back. It's just like you look at it like you're investing money in anything. In this mouse, I'm investing in this mouse company. Well, I'm giving $1. I expect some returns on that every month, because you said in your form that you pay out monthly. And if you follow the stocks, that's what they're doing. That's your dividend check, and it's monthly, because they're getting paid that probably every day, every other day. They're getting paid on that investment that you made without knowledge, and they're banking like hell that you're not going to get in an accident, because that goes against their bond, their insurance, for harming you, for involving you in
So
this scheme.
Robert, in the interim, when they make you believe, and this is the process that some of these insurance guys do when they sell it as these insurance salesmen, they don't want you to know that these derivatives is actually attached to what you've already paid into. So they're really trying to hold everything on the inside for themselves, and you just think everything is copacetic.
Most of them don't know. Most of them don't really know, and they're not paying you from your principal. They're paying you what your principal's making. You're actually invested that much, so that what they're giving you every month is your dividend. That's your money that investment you made, and it's all done with your signature. That's the true value of the whole damn thing. But they're hoping that you don't get a claim against their bond, because then they got to pay you. That's why they can drop you. Well, it's the same thing in courts. It's the same thing with everything. When you attack their bond, that insurance company's going, oh my God, you know what? Fuck this judge, fuck this cop, fuck these people. You know what? This person, you know how much they want? They want whatever you tell them you want. And so they're going to attack them. They're going to go after those people. You don't have to. You were harmed. So you're filing a claim that company's having to pay, which the company is whoever, XYZ. But that's how it's all broke down, really. If you look up security exchange, every single person that can do commerce with you has a trustee, and they have these people in place, and they have to follow that securities exchange rule. Everybody does. And so that's how I've got most of them. That's how it made it a little easier for me to wrap my head around all this, because it's a lot. So that's just
it is.
There's a lot of ways to do this. Not a lot. There's probably 4.
So is
but
it
this one that Keith's talking about is a good one.
So would it be a particular regulations through the SEC that you would look up in order to understand how the derivative works?
I don't know why you would want to get involved in derivatives and investments. Again, that's the person in commerce. We're talking about indemnification to make sure we're not held liable, so we can stay out of commerce, so we can stay out of investments.
They're bound by those rules, so we hold them accountable for it. We're not the ones investing. They stole our fucking money and invested it, and they're keeping the dividend, and they're extracting more money from us. So I'm not part of that shit. The only thing I'm doing is holding them accountable, getting my shit back. Fuck their insurance, whatever it is. I don't care what it is. They've screwed us, and that's how they do it. And it's taxes, it's insurance. When we form our documents, we need to pay the taxes on them, and we get our principal on everything back. Everything's paid for. It's hard to wrap your head around. For me, it is.
Well, it makes sense for me now that Keith also mentioned that too, so I can see where you can protect yourself using the LOI.
It's a major form. It's a major form of protection, and that goes along with that without recourse, without prejudice, knowing how to sign those documents, because they're all contract form, and all you have to do is learn how to express yourself as part of the trust, which I don't think is really all that hard, and why we don't teach it in school to begin with.
Well, because then they wouldn't have their fraud. They're coming in as we are. We're fucking washed out to the ocean somewhere.
Well, it goes to the same thing that, how can you expect to think that you have a healthy, strong nation when you're full of a bunch of dummies that don't even know contract or trust law? How the fuck can you put your commodities and everything out to the rest of the world and be the world leader in that and have a general population reading comprehension of about 7th or 8th grade? I think that's pretty fucking profound.
I'll tell you what, the ones that came up with this concept, this whole thing, man, those guys had their shit together. Because it's covered. All the doors, they give us the answers. Evil.
I've kind of thought about that from time to time, and I've kind of come to the conclusion that this is generally over time just manifested into this. I don't believe someone really thought up all of this and planned all of this out. we started off from consciousness of doing good, and we got sidetracked in humanity somewhere along the way.
This goes back to before the Bible. I mean, this is like in the
Yeah.
Bible. It's wrote.
That's
So somebody came up with it.
well,
Yeah,
I mean, the whole
now
concept, but all the writings
added the
seems to
codes.
be through trickery, though.
Well, they've added the codes and all that stuff to close those doors through time, and now the code books are.
So,
who knows how
what would
many.
be the reason for all the tricks?
Well,
To
yeah,
keep
it's
us
a
enslaved,
process,
basically.
and like you said, through time, whenever they found an error, they corrected the error and perfected it. So it's like you said, time immemorial.
They knew. Yeah, they knew we
Yep.
were asleep, and they just kept adding and taking right under us.
Yep. So the last thing I got here is a short read. Credit facilities, waiver of consequential damages, and their interplay with indemnification provisions. It says credit facility documents typically include a waiver of consequential damages and an indemnification provision. Those are basically the same thing. That's the hold harmless and indemnification. While these provisions are typically part of the boilerplate language in the relevant documents, lenders must be mindful of the interplay between these two provisions to ensure that when taken over or taken together, they provide the necessary protections. Understanding consequential damages and indemnification. In contrast to direct damages, which are the natural and likely consequences of a breach of contract, consequential damages are those losses and damages that do not flow directly or immediately from a breach. While direct damages typically are not waived in a credit agreement, consequential damages are usually waived by the borrower and sometimes waived by both the borrower and the lenders. Remember, all these contracts are borrowing and lending, buying and selling.
Right, Keith. And so that's why you know that some of them already know what they're doing, because like in these rental places, after 90 days, they usually send you a letter saying, how is everything going? Because they already know that they need that 90 days to do the default swap for it to go through for them to be paid. And then they have you keep paying until that next 12, 13 months. So some of them
Right,
already
and so
know.
yeah, and so it happens month after month after month, and nobody ever reconciles the record. And then you get the death certificate, and guess what? They rape, rob, and pillage the estate again to reconcile that debt against the United States. Goes on to say, indemnification is the obligation to reimburse a party for damages they have sustained as a result of the underlying contract. So if we were conferred a nationality of the United States, a United States business that is allowed to create a debt and defer its payment. See what happens there? And that surety is the allowance of creating a debt so you can defer its payment. When you match that concept up with indemnification and show that that's got that full faith and credit seal, and therefore that's where the obligation lies for the deferment of payment, they can't expect the payment from you.
Well, Keith, this is the other thing I'm thinking about. I think it's already a ploy or a plot with these employment corporations, because once they employ you, they usually ask for certain instrumentalities like your birth certificate, social security card, and that stuff. So when you go to apply at any of these other organizations, they are already in bed together. They just do the exchanging of issuance of instrumentalities, and then this is how they already know who to go after. That's what I
Yeah,
believe.
yeah, and we've
That's
got
what I believe
corporations
as well.
today. Yeah, and we've got corporations today that are taking out insurance policies on their employees. What? So the employee dies by a terrible accident, but the company that had that that he died working for happens to have an insurance policy on him. So now they can go ahead and pay out the death claim, but they also get a payment themselves because they had an insurance policy.
Well, they do the same thing with the rental. When you rent from them, they do have a clause in there in that lease showing that they have taken out insurance on the the
The
leasee.
customer, yeah, the lessee.
Yeah, the customer, the lessee. Yes.
Yeah. So credit facility indemnification provisions typically require that the borrower reimburse the lender and agents for damages incurred, including damages that were related to the credit facility and awarded to third parties. Is that bank a credit facility? How do indemnification and the waiver of consequential damages intersect each other in credit facilities? As noted above, under many credit facilities, only the borrower waives the right to receive consequential damages. Only the borrower. And again, remember who the borrower is. It isn't you. You're in fact the creditor. See, ask them to go ahead and file a suit against you as a plaintiff. And then when they get stupid enough and do so, you got Form AO 430, Administrative Office of the United States, which we saw yesterday. Form AO 430 clearly tells us the plaintiff is the debtor and the defendant is the creditor. So let them name you as a defendant in a suit. However, borrowers often negotiate that the waiver of consequential damages be mutual. Okay. Meaning the borrower would not be liable for any consequential damages either. While this approach seems relatively straightforward, an unintended result in the drafting can occur where the waiver overrides the indemnity. The intent of mutual waiver of consensual damages is that neither the borrower nor the lender will pursue each other for consequential damages, and not that the borrower will not indemnify the lender if it is found liable to pay consequential damages to a third party. See, it's saying that the lender will pursue each other. The borrower nor the lender will pursue each other for consequential damages, and not that the borrower will not indemnify the lender if it is found liable to pay consequence. In other words, the negligence and gross negligence and those other things we saw earlier. If you're competent, then that goes. But if you end up being negligent, now you're liable. This is the misfeasance and malfeasance we talked about. To make clear, mutual waiver of consensual damage provisions should explicitly exclude third-party damages from the waiver. In other words, you're not going to allow damages for the surety. That's the third party. You're the one in the direct contract, and you're laying off those liabilities to the third party because that's what it was meant for. It was meant to take the liabilities. It was meant to be beat up, not you. Below is a version of a carve-out often seen in the market. It says, other than in the case of any credit party, in respect to such damages incurred or paid by an indemnity to a third party, or which are included in the third party claim, and for any out-of-pocket expenses related thereto. Including this carve-out will help make it clear that the waiver is not intended to override the indemnity, and that the borrower remains liable to indemnify the lender for third-party claims, even if those are consequential damages. So if the borrower causes me to suffer loss through the third party, I get the consequential damages through the third party. For additional information, please reach out to your regular Meyer Brown lending contact. And it's got more stuff. It's a nice little site that I came across. I didn't think too much about it, but it had that little bit of information that I thought was pertinent in relations to the indemnification and the holding harmless as relates to the waiver. And we have to understand, again, using these contract terms, we have to know what those contract terms mean. If we don't, we need to do the research and stop putting them down on these pieces of paper and then signing, or signing pieces of paper that have them on there without understanding them. It's imperative we teach our younger generation to stop and start thinking about what's on those pieces of paper, because as the older generation, they should be hearing us screaming and hollering about how corrupt this shit is. It should be the top priority on their mind, not some dude being able to wear a dress or some chick being able to flatten her chest and wear men's suits and stuff. It's getting ridiculous. We need to start getting real with our younger generation and let them know something seriously is very wrong in the education and the documentation that we've been told that we need to start, that they need to sign. Go ahead, brother.
That's one thing I am grateful for there, even though you know a little bit about my my past here, and but I've had that. I've been fortunate to have those conversations with my two offspring there, and it is beautiful. So, because there, like you said, there is a whole lot of. You know, I keep going back to this as I was talking to my kids earlier. It seems so simple to me now for some reason, and I don't know. It's so hard for me to see why people, as much as you see in the world today, it's as simple as right and wrong. You already know what we need to do.
Well, I would agree with you partially on that, but not quite, because the reason I say that is like, all they already have us divided up as a chessboard in color black and white. What they would
All I can
allow
control
to
is me.
you, you what they will allow you to be able to do and give you the opportunity to be able to express knowledge to your children, they restrict the other people. So, it's like one in one, half a dozen in the other. And I yield.
Yeah, I could just, I feel I could only, or I'm responsible for myself. I didn't get that download that I have to get permission from government or a public official in this realm of the universe. I didn't get that download from the Great One.
Well, see, the process that the example that I'm trying to say is that I remember earlier on, I had a friend, right? And we were really good friends. We didn't see color in any one of us, but when we would go shopping together, what they will allow her to do, they would look at me even harsher, or as me being the one doing something nefarious. But it was always, the other way around. So like you said, they pit us once against one another. So like I said, what they will allow one, they will not allow the other, based on these colored constructive forms that they've created. So it is what it is.
Yep. All right, folks.
Absolutely.
Well, with that, we come to the end of our stream for tonight. You guys got anything on the way out?
Well, I'll go first. I noticed you had 26 people in here at one point. I think it is beneficial to a lot of people that may come into this stuff when we're all up here collaborating and bringing different angles. I think it helps people with clarity. You know, certain people learn certain ways, certain things trigger people, and you know how it is. And we all learn differently. And
Yep.
I love it. So I'm going to get in like I always do. Be the change you wish to see, and popularity without a positive purpose is valueless and pointless to life. Much love and many blessings to all.
Absolutely. Appreciate it, brother.
And be right behind you, brother. I would say that I agree and I concur with what you say. But I think one of the things is that when we're learning these things, we have to go through the same process of what we're learning. So if they show us to create a document and do it that way, we do it, but then we go and do what they call the reverse engineer of what they told us to do the opposite to get the truth of it all. And I yield. Thank you.
Right, and that's why research is so important, guys. I'll never get tired of telling you. Don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. What do you got there, Robert?
It's all a bunch of bullshit, the whole thing. No, I'm kidding. No, yeah, I agree with everybody to a certain extent. Yeah, all that good stuff. Thank you.
Absolutely, absolutely. Well, thanks for having you coming up, guys, gals. I appreciate everybody's support. Please hit the like, share, and subscribe button for me. There's a PayPal link down there for anybody who wants to share some love. And you guys know me. I love you, but I don't give a rat's ass whether you love me back or not. And I say I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. We'll see you guys next time.
Peace,
Bye now.
brother.